explicitly set out to destroy both universities and unions. It makes for challenging times heading in here. And I know the focus of my 10 minutes today is supposed to be Bill 32 and labor legislation, but I just want to flag at the beginning that this also comes at us in Alberta at a time when our provincial government is in the process of cutting 20% of the post-secondary budget in the province. And like our friends in Ontario, also moving towards performance-based funding measures, and in the process right now are reviewing the entire post-secondary system. So this labor piece is just one of many that we're dealing with right now. And for context on the labor piece, for years, for decades, but especially after Ralph Klein comes to power in Alberta in '93, we had unquestionably the most regressive labor legislation by far in the country, both in terms of employment standards and in terms of the labor relations code. The NDP government that was in power here from 2015 to 2019 made some big changes which came into effect in 2018. But because we were already so far behind, what those changes accomplished essentially was to bring us into the middle of the pack in terms of labor legislation across the country. Nowhere near the cutting edge that many of us activists and unions wanted the NDP to move towards. So Bill 32 is the big one that I'm speaking about today. It's called the Restoring Balance in Alberta's Workplaces Act. It passed in late July. And it actually not only undid most of what the NDP had accomplished, but it actually moves labor legislation in the province further back than we actually were pre-NDP. So if you can imagine what that looks like. It makes a number of significant changes to employment standards, like reducing access to overtime, holiday pay, vacation entitlement. It makes industry-wide variances easier to get for employers, reduces layoff notification requirements, and a bunch of other changes that, because it's employment standards, I'm not going to focus on here. Instead, I'm going to focus here on some of the key and most egregious changes that Bill 32 makes to the actual labor relations code. And the first one of those that I want to touch on is in terms of financial reporting for unions and what it imposes. It requires that a union provide each member, and that's important, with a financial statement for the preceding fiscal year. Because most unions already provide financial statements, but this requires us to put those statements in the hands of each member. Members can then complain to the board about the financial statements, and the board can order that it contain more information or different information. So what this does by putting it into members' hands, it actually puts the detailed information within access of the employers if any member just wants to pass it along at that point in time. Instead of right now, where if members want detailed financial information, they have to come into the office to get that. It also dictates to unions exactly what they must include in their statements, the financial statements, which is a level of interference in the affairs of unions that is actually shocking, whereby the government and the labor board will be able to dictate what goes into the statements, what you have to provide, and how much detail. The big change in Bill 32 revolves around union dues. So it starts by articulating that unions must determine how much, either in dollar amounts or in percentage amounts, of union dues will be spent on activities under the code. So these are things like collective bargaining, representation, grievances, etc. And how much will be spent on, and this is in quotation marks, political activities and other causes. These include social causes or issues, charities, non-governmental organizations, organizations or groups affiliated with or supportive of a political party, or any other activities prescribed in regulation. So you have two essentially groupings of activities that we spend money on. No dues can be collected at all until the union shares these percentages or these breakdowns and information on activities with all the members. And then again, any information determined in regulations in whatever format is determined in regulations. Each member must then provide a written election authorizing the union to receive the amount or percentage of dues to be spent on the political activities and other causes portion of union dues. If the member does not elect to pay that portion of dues, then the employer cannot deduct them and remit those dues to the union. And the union can in no way penalize or take action against a member that chooses not to pay that political and other activities portion of dues. It's still unclear how much detail must be provided by the union about its plans for spending, and it's still unclear what happens if the union doesn't raise enough money in dues to implement its activities and plans. It's also unclear how specific amounts are to be calculated. For example, the big concern for us in Alberta faculty associations is how will the dues that we pay to CAUT and to our provincial confederation, and for those that are affiliated to the Alberta Federation of Labor, how will those dues and affiliation fees be considered under the legislation? All of those bodies engage in political action and advocacy on some level, but they also provide support and information around bargaining and member representation. So how do you split those percentages? Likewise, how do you do the calculation for a funded president or elected member of a union who spends a part of their time engaged in lobbying, advocacy, and external communications or larger policy issues? How do you determine which part of that is core collective bargaining business and which part of that is political and other activities business? Ostensibly, all of those disputes and questions will be settled by the Labor Relations Board, but what we don't know is what guidance and definitions will be used by the board to determine those disputes and resolutions. And then another big area in Bill 32 is around picketing. Make secondary picketing illegal unless specifically authorized on a case-by-case basis by the Labor Relations Board. It also makes it illegal to obstruct or impede a person who wishes to cross a picket line from crossing the picket line, meaning it would be illegal to delay anybody wanting to cross the picket line even for a minute under this legislation. Both of these provisions should be read in conjunction with the province's recently passed Bill 1, which enables the government to label any sidewalk, road, parking lot, railroad, or pretty much anything else it wants as essential infrastructure, and thereby makes protests, obstruction, and disruption on that essential infrastructure illegal and punishable by thousands of dollars in fines. So those are the big pieces of Bill 32. Some other quick ones that I don't have the time to go into detail. All of the provisions in the academic staff collective agreements to resolve negotiations by binding arbitration are made null and void, including any arbitrations ongoing as of July 7th, which is when the bill passed first reading. It allows parties to negotiate agreement renewals early to avoid the open period, and it extends timelines required for certifications. Interestingly, academic staff associations, GSAs, and postdoc associations are currently excluded from having to comply with the requirements pertaining to dues, but the bill states that the provisions will be proclaimed for these bodies at a later time. It's unclear why or when they'll be proclaimed. We just know that at some point we will be proclaimed. In terms of how we're dealing with this, as you can imagine, significant parts of Bill 32 are, in our estimation, in direct violation of the Charter, specifically freedom of association and freedom of expression provisions. Through the Confederation of Alberta Faculty Associations, we've been working closely over the past year, coming together regularly with a large group of public and private sector unions, advocacy organizations, and civil society to share ideas and information on fighting back against the Kenny cuts and to fighting for labor rights. Through that process, we're in touch with the Alberta Federation of Labor, who is organizing its affiliates and some large non-affiliated unions to mount a constitutional challenge of the bill. The Alberta Union of Provincial Employees, the province's largest public sector union, has already mounted a constitutional challenge of the province's Bill 1, the anti-protest law. We're watching closely what the large public sector unions are going to be doing to see if they comply and how they comply with the legislation and how they are regarded to comply. Our academic staff associations in this province have only been under the Labor Relations Code, recognized as actual unions for a couple of years now. And although a few of our faculty associations in the province have done some tremendous work in terms of getting their members to identify as union members and activate as such, many of us still have a long way to go in this regard. So for us, the work ahead involves regular and active communications with our members, getting them to understand that this legislation presents a direct attack on their rights, and ensuring that they see themselves in the union and come to see the work of the union as their own. This is a pretty big culture shift for many of us in Alberta, and I speak on behalf of the University of Alberta as one in particular, where we haven't historically had that culture in place of us identifying as a union or even as workers in many regards. We're not necessarily yet fit for purpose for this kind of battle, so we've got to ramp it up and move ahead very quickly on this. And in that vein, just before I wrap up here, I want to point out that the messages of solidarity that we have received so far from other provinces, from other faculty associations, have certainly provided a very helpful tool in terms of reaching out to our member on these issues and helping them identify in this capacity. So I will stop there, and I look forward to the discussions.
Thank you, Ricardo. Next, we have Janet Morrill.
Unmute myself. I don't know whether I can share my screen or not, but I'll just put my PowerPoint ahead in front of me. Oh, this is weird. Oh, there we go. All right. I don't know whether everybody can see that, but thanks very much for inviting me. So I'll be talking for the next 10 minutes, and I'm going to try to concentrate a little bit on the highlights of some of our legislative challenges that we've had. In terms of the Manitoba legislation that we have in this regard, our version is called the Public Sector Sustainability Act, which came through in June 2017. So the things that I've highlighted here are basically the important features of our legislation that ended up being important in the court decisions that have come through. Is basically very similar to the Nova Scotia legislation. I think the thing that caused the greatest concern for us is our legislation included a provision where even if you managed to get your employer to negotiate a wage rate that was higher than the 0, 0.75, and 1, any wage increases above that limit would become a debt due to the employer or the government as soon as it was proclaimed. So, hold on a second, I'm just trying to figure out where I am here. Okay, there we go. So this was of great concern for us because, you know, in the worst possible case, we might, if we'd managed to extract a higher wage from our employer, that bill would be proclaimed. All of a sudden, our members could end up with a bill of who knows how much that they would have to pay in terms of wages that they had already received. Nevertheless, our legislation was never proclaimed, which was one of the things that our government was trying to use as a defense. Okay, so moving the screen. So that legislation was in 2017, but we actually had problems starting in 2016. So we were having our negotiations in 2016, and what happened was, long before that bill was even introduced, the government was interfering behind the scenes. And so we didn't know about this, but the government persuaded the employer to take back a salary offer on the table. We ended up filing an unfair labor practice because of that. We had a 3-week strike, and we were forced to accept a 1-year deal with a 0%, which was the first year of the Public Sector Sustainability Act legislation, which at that point had not even been introduced yet. So next slide. So then in 2017, we were in negotiations. At that point, the Public Sector Sustainability Act had been passed, but not proclaimed. So one of the first things that was important is that we had our lawyers on speed dial, which is unfortunately, I think, a necessity these days. The employer was constantly checking back in with the government, who was insisting that it would be 0.75 and 1% increases for the first 3 years. Nevertheless, our employer really wanted to have a 4-year deal. So the interesting thing was what was going to happen in that 4th year. We ended up with a salary reopener, which is actually taking place right now. So this was one of our strategies, was having this reopener. It remains to be seen how this is going to be played out. But one of the things that we did have is a specially worded ratification ballot. So the wording of that, if we can move to the next slide. I'm not sure whether I'm seeing Justine's screen or my screen, but this is what our ratification ballot says. And so in the court judgment, they paid attention to this ratification ballot. So it seems like it did provide us with some protection, although it still remains to be seen how this is going to play out. So in terms of our legal battles, the first legal battle we had was the unfair labor practice. And that was successful. We ended up getting awarded basically the maximum penalties that were available, that the U of M had to pay $2,000 to each one of us and $2,000 to UMFA, and it was for failing to provide timely disclosure. Waiting over 20 days before filling us in was an act of misrepresentation and a violation of the duty to bargain in good faith. So this was referring to the fact that the government was interfering behind the scenes, made the U of M take their salary off the table, but they hadn't told us about that. The other parts of our unfair labor practice were not upheld. So I think this is another part where I think one of the most important things you can do is keep up those connections with COUT and with all of you, because the COUT Defense Fund and the financial support and the moral support from everybody during this was just incredibly important to all of us. The other thing that's happened is now in Manitoba, we have the Partnership to Defend Public Services. So this is the Manitoba Federation of Labor forming this coalition that is fighting against the Public Sector Sustainability Act. And I think that's the other lesson that's super important, is that you need those linkages, and that banding together is incredibly important. And so, you know, when Ricardo talks about the Bill 32 getting in the way of, you know, perhaps spending money on those things and those kinds of activities, is just absolutely reprehensible, because it's one of the most important things in our arsenal. So the Partnership to Defend Public Services, the first thing they did was they sought an injunction to prevent the proclamation of the PSSA and to declare its terms and conditions invalid in the interim. That was unsuccessful, but what the courts did do is they fast-tracked the lawsuit. So in the next slide, that lawsuit already has taken place, and we just got our judgment last month. So, I mean, the central arguments that were made by the Partnership to Defend Public Services was that this was substantial government interference in collective bargaining, that you couldn't justify it through a notwithstanding clause, that it was necessary. The fact that they didn't proclaim it is irrelevant because the law was in effect. It was not justified, sound, or necessary. So this was important because the government had gone through sort of this sham consultation that was supposed to substitute for collective bargaining, but they ended up basically giving the Nova Scotia legislation. And so one of the things our lawyers argued was that there really couldn't have been any kind of consultation, because you just ended up copying what another province was doing. And I think we've all found that it reduces your ability to bargain for other concessions. I'll talk about that in a minute. So where we are now, the Partnership to Defend Public Services was declared unconstitutional. We don't have the remedies yet because that's a bifurcated judgment. And we are in our salary reopener discussions that we'll see how those work out. But I think the things that we've learned from this that are probably the most important, let's go into the next slide, is it is really, really challenging. Our members are angry with the government, but I think as well, sometimes they're just not sure who to be mad at. They're also mad at the employer for listening to the government, but then they're also mad at the union leaders. And I think one of the things that we also really need to be paying attention to is the mental health of our union leaders, because this is really, really, now I can say as a past president, that this can be a really, really difficult and tiring, frustrating, incredibly frustrating environment to be dealing with. It is very difficult to bargain because the power dynamics are completely distorted. When you don't have the money on the table, you don't really have much of a hammer other than going on strike, which people just don't want to do. Things have to get really bad before people will be prepared to hurt their students in that way. But that's kind of at the point where that's all you can do. And there's a frustration because you have this feeling that your decision makers aren't at the table. So you do sort of have that sense of learned helplessness and a feeling that you're wasting your time. For the institutions that have landed under these political regimes, you lose an awful lot of competitiveness. We've lost a lot of faculty. Our salaries have fallen really far behind. And so it's a terrible thing for the university. The other thing that's happening is you're fighting an ideology in addition to austerity. When COVID started, our government came up with this idea of government 2.0, where they wanted us to take a 10% cut and to envision what a 20 or 30% cut would look like. And so when that came through, our university, to its credit, said, can you just cut our operating grant and let us deal with this? And they said, no, we want you to cut your labor costs. So it wasn't just a question of needing money to fight COVID. It was that they wanted public sector workers to be earning less. And what was interesting was how much the public actually pushed back on that. So while public perception is sometimes difficult to assess, sometimes I think we think the public is not on our side, but I think actually they are. Our Manitoba government has filed a notice to appeal that ruling. But again, what is interesting is our Winnipeg Free Press was very critical of the government's decision to appeal. They said it delays good faith bargaining, it's suspending the province's legal duties as an employer, and it's not a prudent use of time or money and cannot be viewed as fully in the public interest. So it was great to see that kind of support coming from our newspapers. And I think sometimes we forget about maybe how much the public is on our side. So I think that's my 10 minutes, and I will pass that over to the next person.
Thank you, Janet. And next we have Peter Engelmann.
Good afternoon. I'm here to speak to you about the situation we have here in Ontario, and in particular, legislation passed by our Conservative government that significantly interferes with the collective bargaining rights of unions. The bills in question are Bill 124, which is called an Act to Implement Moderation Measures in Respect of Compensation in Ontario's Public Service, and Bill 195, which is entitled Reopening Ontario, a Flexible Response to COVID-19. Now, the doublespeak or misnomers in these, maybe not quite as bad as the bill Ricardo talked about from Alberta, but you get the sense. This is really about passing government revenue shortfalls and making public servants and broader public servants pay for them. And on flexibility on Bill 195, it's just giving the government an awful lot of flexibility to interfere with collective bargaining rights even after the COVID-19 emergency is apparently over. So just, legislation isn't always what it says it is. So I'm going to spend most of my time talking about Bill 124 because it directly affects faculty associations and their members in our province. Bill 195 really only does this indirectly. Bill 124, very similar to the law that Janet just talked to us about from Manitoba. It is expenditure restraint legislation. It came into effect a couple years after the Manitoba law, so in late 2019. It imposes moderation periods, that's the term they use, for 3 years, which restrict increases in salary rates and existing or new compensation to a ceiling or cap of 1% in each of the 3 years. Unlike the Manitoba law, it is forward-looking. In other words, it does not override compensation increases that may have been gained in collective bargaining or through arbitration awards that were in existence at the time the legislation came into effect. It is also slightly more generous than the Manitoba legislation with respect to the wage caps, but it is still a significant restriction on unions' collective bargaining rights. In addition to the caps over the 3 years, it also restricts parties from what they call making up the difference. So in the 4th year or the year immediately following the moderation periods, you can't get a significant increase. The bill applies to a very wide range of employers. Obviously, it includes the core public service and Crown agencies, also school boards, public hospitals, not-for-profit long-term care homes, the Children's Aid Society, and importantly for you, all universities and colleges. So given that the law does not apply retroactively, how it works is it depends on the status of your collective agreement as at June 5th, 2019. If you had a collective agreement in force then, the moderation period begins the day after that collective agreement expires. And if there was no collective agreement in force on June 5th, in other words, it had expired, the period begins the day after the expiry of the previous collective agreement. Although there's a 1% ceiling to workers' base rate of pay over a 12-month period for each of the 3 years, the cap does not extend to increases for seniority, performance merit, or education. So if there's a salary grid that you would normally progress through, or there's performance increases, they're not counted in the 1% cap. But this is an overall compensation cap as well. So it includes salary, benefits, discretionary and non-discretionary payments, and is calculated on the basis of the average of all employees under the collective agreement. Enforcement of this is interesting. It gives the power, a huge amount of power to the cabinet and to the Minister of Labor. And it allows the Management Board of Cabinet to access a wide range of information to monitor compliance. And it gives the Minister of Labor increased discretion to make orders as to whether or not a particular collective agreement or arbitral award is inconsistent with the Act. Now, sort of remains to be seen whether they're going to hire up enough staff to actually look at all these collective agreements that they're receiving, because they're receiving collective agreements that are being negotiated or interest arbitration awards all the time. The minister also has exemption powers. So even if a collective agreement or award is inconsistent with the Act, the minister can still exempt employees or classes of employees from the Act's application. We've seen this very recently in Ontario, where by regulation, the government increased pay for frontline workers in hospitals, long-term care homes, etc., by $4 an hour. And that was exempted by regulation from Bill 124. Unfortunately, that did not apply to employees of universities or colleges, who may have employees providing face-to-face services with students and others that might put them at increased risk of exposure. So there are many other provisions of Bill 124 that are of interest. One of them that's particularly interesting to me as a union side lawyer is the fact that we can't challenge this bill before interest arbitrators. We can't challenge it before the Labor Relations Board. It's really only left one challenge available. And that is a challenge like the one Janet talked about, where court action was brought to challenge this as a violation of freedom of association under Section 2D of the Charter. And here in Ontario, the Ontario Federation of Labour has filed a charter challenge to challenge this bill. The majority of faculty associations have joined the challenge, and many, many unions under the OFL umbrella. So similar to the Manitoba Federation of Labour challenge. Several of my colleagues are actually working on this case, including my partner, Colleen. The OFL challenge has been brought on behalf of over 250,000 broader public sector and public sector employees. Some unions, including teachers unions and nurses unions, have brought their own charter challenges. And Janet talked about the successful challenge in Manitoba. And I must say, despite all this depressing news out of Alberta and elsewhere, that decision really was a breath of fresh air. Unions, although we've been successful in challenging legislation, especially the most draconian legislation, the Expenditure Restraint Acts typically have not been challenged successfully. So this Manitoba case is a breakthrough, and it's certainly going to assist us in our challenge here in Ontario. Now, our challenge may not be quite as factually strong as the one in Manitoba, because the Manitoba one actually clawed back increases that had been negotiated. So ours is only forward-looking, and there are some other things that aren't quite as good. It is still a significant and substantial interference with collective bargaining. From a faculty union perspective, legislation is particularly troubling because this is the first time I'm aware of that government expenditure restraint laws are being applied to universities and university employees. Because, I mean, universities, at least under the Charter, have always been considered independent or at least quasi-independent employers. And as we all know, the percentage of funding that comes to universities from provincial governments is ever decreasing. So, you know, that is a troubling extension of expenditure restraint laws in our case. I wanted to very quickly talk about some bargaining considerations, because we're getting a lot of requests from union clients. You know, how do we deal with this? One of the things we have been pushing is requesting extensive financial disclosure for costing purposes. Given salary caps and compensation caps, it's particularly important that you cost all of your proposals, and you need to know exactly how much the employer's been paying on average for benefits and other compensatory items, so that you can frame your bargaining proposals appropriately. Secondly, you're going to craft proposals that fully maximize the 1% salary and compensation caps. And again, that costing information is important. And for the purposes of charter challenges, I think it's also important to table proposals regarding what you would have been seeking but for the legislation. Thirdly, obviously focus on non-monetary gains. Given the caps, look at better leave provisions. Are there other areas of member concerns, whether contracting out of work, layoffs, or what have you? Now's the time to try and make some gains on the non-monetary side of things. Fourthly, consider the length of your collective agreement. You could go shorter, perhaps 2 years, in the hopes that this government gets voted out of office, or that our charter case is heard in time and this is struck down, or you could attempt a longer contract to get some additional compensation issues, perhaps at the very end. But you're going to have to be careful so that you're not looking like you're catching up. Lastly, and Janet showed part of this on her screen, consider some language in your proposals in light of the Charter Challenge. So we're advising our union clients to attempt to obtain agreements from their employers that the collective agreement monetary terms are without prejudice to the rights of their members should Bill 124 be found unconstitutional. Alternatively, in your interest arbs or in your bargaining, say that your bargaining and or your awards are without prejudice to those rights, and that will be focused on when bills is found to be constitutional or not. Very quickly, I'm out of time, I'm sure. Bill 195. Our concerns really here are about democratic and really public oversight. Ontario, unlike other jurisdictions, like many jurisdictions in this country, has powers to issue emergency orders. And I know that many governments in this country issued emergency orders as soon as the COVID pandemic was declared. We have an old law called the Emergency Management and Civil Protection Act, EMCPA, where if the government declares a state of emergency, as it did, it can make emergency orders that have a huge impact, that can override statutes and override collective agreement provisions. That can initially be decided by cabinet for 14 days and a further 14 days, but then if it's going to last more than 28 days, it has to go through legislative renewal. And the legislature has to meet monthly to renew a state of emergency if it wishes to maintain emergency orders. And these emergency orders give, as I say, governments extensive powers. And the bill is very broad. It applies to hospitals, municipalities, long-term care homes, etc. Thankfully, it does not apply to universities and colleges. But many of our union clients have seen their members redeployed to completely different work, other work locations, different work schedules, etc. And of course, there's been suspensions of grievance provisions. These restrictions are now being continued under Bill 195, despite the fact that the bill recognizes the emergency is over. And what is most concerning about this bill is that it removes the legislature's role in maintaining or ending a state of emergency. It gives the cabinet the power to amend or extend emergency orders and for up to a year. And this really is a dramatic reduction in democratic oversight. So, the concern here is, are they going to try and apply this elsewhere? And are we going to see more of this in the future? Thank you.
Thank you, Peter. And our final panelist is Peter Mckinnis.
Thanks, Sue, and merci beaucoup to COUT staff for inviting me to participate in this town hall. As I'm from Nova Scotia, a province with a long history of anti-unionism and stubborn labor resistance, I've been asked to comment on the infamous Bill 100. This is the Universities Accountability and Sustainability Act of 2015. Yet to be officially invoked, Bill 100 remains on the books and is still very much relevant to the economic and political spin-offs during this pandemic. When implementing Bill 100, Nova Scotia University essentially declares a financial crisis beyond its ability to manage, defined in the legislation as a significant operating deficiency. Specifically, an annual operating deficit or cash flow deficiency in at least 1 year over a 5-year period, or a pattern of operating deficits or cash flow deficiencies over 5 years. Now, if you look at this legislation, this is a very low threshold. As far as we know, operating deficits and year-over-year debt are all too common in the post-secondary education sector. Thus, the potential for an artificial state of emergency serves as a perpetual threat to good faith collective bargaining. Importantly, the law also bypasses financial exigency clauses in collective agreements, which usually require detailed evidence of financial insolvency prior to action. What about the campus community? Under Bill 100, when a significant operating deficiency is declared, unionized employees and their union, and I'm quoting from the legislation, shall not declare, cause, or continue a strike against the university. No unionized employee shall participate in a strike against the university. The union may not commence or continue any grievance that relates in whole or in part to the development of a revitalization plan. Further, No person or organization shall do anything to prevent or impede a unionized employee's compliance with the law or aid and abet a unionized employee to comply. So this is awkwardly written, but you get the point. Obviously, this last bit interferes with our essential academic freedoms of intramural and extramural expression. Finally, universities may not execute a collective agreement with any bargaining agent that represents any unionized employees during this period. There's also a punitive element, as you're seeing in other legislation. A person who contravenes the legislation is guilty of an offense, is liable upon summary conviction of a fine of not more than, I'm glad to hear this, $100,000. And in the case of a continuing offense, a further fine of $10,000 for each day in which the offense continues. There's also fines committed by non-union persons at a reduced rate. Turning to the specifics of this plan, a university's revitalization must include, number one, a strategic assessment of the university's strengths and weaknesses and expected future challenges in the post-secondary education. So here we are in 2020, and does anybody want to predict the future of PSE in 2021, 2022, and beyond? Anyone? Probably not. Number two, a description of the university's long-term strategy for financial sustainability, including present and projected student enrollment and plans for student retention. So this is indicating, as it is in many other provinces, a continued dependence on tuition revenues and movement away from any stable provincial funding. Number three, a plan to achieve a focus on high quality, efficient, and effective learning through appropriate delivery channels for students. So this may indicate, as we're seeing now in the pandemic, a reliance upon online courses, not only during this health crisis, but in the post-pandemic recovery. The legislation has the usual standardized buzzwords and neoliberal baffle grab, including fostering world-class research, internationally competitive, turning research into business opportunities, entrepreneurial and innovative workforce. I think synergies must be in there somewhere. But more concretely, cost savings will be achieved through collaboration with other universities, including the elimination, consolidation, and specialization of faculties, departments, and programs. Where a university's plan does not include any of these proposals, it must include analysis of and reasons why it does not. Oh, and all of this is to be completed within a mere 6 months of any application, so good luck with that. Given the Supreme Court of Canada's jurisprudence in the British Columbia Health of 2007, Saskatchewan Federation Labour 2015, and more recently the BC Teachers Federation 2016, this Nova Scotia law is probably a violation of charter rights in the freedom of association and collective bargaining. But legal challenges, while important and vital, are best served as one avenue that must be combined with more immediate activism. So what did we learn from our experience with Bill 100? Legislation is often hastily and maybe even moistly drafted, and therefore contains incoherent sections that should be highlighted. The initial draft of Bill 100 had provisions to merge universities, and even permitted hostile takeovers. So perhaps Dalhousie could get their hands on Acadia as a satellite campus. Yet yielding control is something that both senior administration and their boards of governors abhor. So this potential surrender of institutional independence was always a pressure point to be exploited. Further, lawmakers usually do not understand the internal governance structures of universities and colleges. They assume that faculty and staff are one amorphous mass and that students form another undifferentiated blob. This is another potential pressure point. It's also vital to note that university senates or their equivalents have a crucial role in academic decision-making. Emphasis must be placed here on the building and maintaining of effective governance process prior to any fiscal emergencies. COUT has done some recent work in this respect, and members should consult our website for details. Given that Bill 100 was running through the provincial legislature in April and May, our faculty association realized that we had to provide analysis to our members to take action. Otherwise, they may not have the time or the inclination to actually participate. This came out, of course, at the end of term rush. The takeaway here, inform your members how to resist. Don't assume they'll do so spontaneously. Back then, we mounted an effective campaign to have faculty associations appear before the Nova Scotia Law Amendments Committee. We retained legal counsel to appear in Halifax at Province House. This was Ray Larkin of Pink Larkin. As a result, the legislation was slightly modified, but the government had a majority, so it was going to go through. But more importantly, perhaps, we formed coalitions between the Nova Scotia Federation of Labour, the Canadian Federation of Students, the Nova Scotia Government Employees Union, and the Canadian Union of Public Employees to make common cause over anti-union laws, as these public sector unions and allies had already felt the brunt of government attacks. We used social media effectively. We set up a Twitter storm. We republished links to supportive blogs. We designated spokespersons to frame a consistent message to the public, but it also was messaging our own members. We cold called, that is, contacted journalists, and quickly responded to calls from the media for commentary. So you really got to get on this or you'll be sidestepped. We went on CoutGen, our listserv, to solicit letters of support nationally. Then we sent those excerpts back to our own campus community to keep them informed and motivated. So we're creating something of a feedback loop of mutual activism. And finally, Cout Council passed a unanimous motion of support and censure should any Nova Scotia university invoke Bill 100. So it hasn't happened yet, as we said. Finally, in prepping for this town hall, I searched my files for materials reaching back 5+ years. And fortunately, and perhaps maybe unexpectedly, I'd archived much of this correspondence. And it helped me remind me of the detailed actions we took back in the day. So you need to do the same. Archive your campaign. After it's over, for you or your successors will forget the important details for the next time. And there will be a next time as we battle over the future of the academic workplace. Thanks, I'll be interested in the discussion.
Thank you, Peter.